Hello, viewers. Good evening and greetings from Livelaw Academy. I welcome you all to this part 2 of the Judiciary demo class on charge, discharge, and framing of charges by Justice V. Ramkumar. For some of you who could not join us last time, I will introduce Justice V. Ramkumar once again for you. Justice Ramkumar did his LLB from Government Law College, Mumbai. He enrolled as an advocate in the High Court of Kerala in the year 1979 and was directly recruited as a district and sessions judge in the year 1987. Sir also served as the law secretary to the Government of Kerala and was appointed as a permanent judge in High Court of Kerala in the year 2004, a position that he held till his retirement in the year 2012. Further, he served as chairman of the advisory board under Kerala Anti-Social Activities Prevention Act 2007 from 2013 to 2016. Apart from this, Justice Ramkumar has authored many books and many articles on important legal concepts in question answer format, also, which you can find on Livelaw's website in case you ever want to read. Thank you so much, sir. It is my honor to be here in this session with you. The last session, also, as we joined, was indeed very wonderful and very easy to understand. Complex issues made very simple. I welcome you all, and the mic is over to you, sir, please. Sir, I think you're on mute. I request you to please unmute.
Am I audible?
Yes, sir.
Thank you, Roshi. The other day we discussed the Bible of this topic, namely framing charge and discharging the accused. The leading case, that is William Slaney versus State of UP, State of Madhya Pradesh, I'm sorry, State of Madhya Pradesh, AIR 1956, Supreme Court 116. We discussed the entire occurrence in that case. We discussed the entire case law. We discussed in fact, any issue pertaining to omission to frame a charge or irregularity in framing charge or illegality in framing charge, you will look up to William Slaney's case, Constitutional Bench decision rendered way back in 1956. 5 judges. Now, today we are going into the meat of the matter. I told you the other day, even at the risk of repetition, let me tell you that court has a very responsible duty while deciding to discharge the accused or while deciding to frame a charge against him. The expression charge has not been defined with precision either under the CRPC or under the Bharatiya Nagarik Suraksha Sanhita, BNSS. Now, any mistake or error or omission at this stage of framing charge or discharging an accused can bring about a failure of justice. There is a practice among certain judges to make a verbatim reproduction of the police charge. Police will file a charge sheet before the court. They simply copy the police charge. That is a bad practice. A judge has to independently apply his mind and frame charge in accordance with Chapter 17 of CRPC, that is Code of Criminal Procedure 1973, corresponding to Chapter 18 of BNSS. After reading the court charge in the language of the court, it has to be read over and explained to the accused in the language he understands. And it is only thereafter that his plea is to be taken. His plea, whether he pleads guilty to the charge or whether he pleads not guilty to the charge, is to be taken only after making him understand the entire nuances of the court charge. The police, in fact, the police report, that is the final charge sheet or closure report, to the effect that offense has not been made out in investigation, is not binding on the court, which has to make an independent examination of the materials produced by the prosecution along with the police report. Supposing the police report is to the effect that no case has been made out, therefore we are filing a closure report. That is not the end of the matter. It's not binding on the court or the magistrate. The magistrate can scan, peruse the materials produced along with the police report, and if the magistrate finds that an offense is made out through the statement of one witness or other, then notwithstanding the conclusion reached by the investigating police officer, the court is at liberty to take cognizance of the offence and proceed further, instead of accepting the closure report and dropping the proceeding. That is not a proper mode of uh, doing justice to the case. Now, in a famous case, State of Orissa versus Habibullah Khan, 2003, volume 12, SCC 129. 2003, volume 12, SCC 129. Judges are Y.K. Sabharwal and B.N. Agrawal. Y.K. Sabharwal and B.N. Agrawal. The two judges bench of the Supreme Court held that, notwithstanding the conclusion of the investigating officer that no offence has been made out, the court can independently scrutinize the materials produced along with the police report and take cognizance of the offence, if any, made out from those materials. Likewise, even in cases where the investigating officer has reached a conclusion that the alleged offence has been made out and he has charge sheeted the accused, court has the last word to say that no offence is made out if the materials produced do not disclose the commission of an offence. So the conclusions reached by the investigating officer after the conclusion of investigation is not binding on the court. That does not mean that court should disobey or disregard the police report. Court should, notwithstanding the conclusion reached by the investigating officer, court should meticulously scan the materials produced along with the police report, and if an offence is made out, then notwithstanding the investigating officer's conclusion that no offence is made out, court can take cognizance of offence. Vice versa also. The police charge is to be that the accused is to be charge sheeted for specified offences. And if the materials produced along with the police report do not disclose the commission of an offence, then notwithstanding the conclusion reached by the investigating officer, court can drop the proceedings, refuse to take cognizance of the offence. Now, any law is better understood when applied to concrete fact situations. That explains why the subject is introduced to you by me in the form of a questionnaire. The questions have been so framed as to enable you to apply the statute law and the case law to the situations covered by each question. My role is only that of a facilitator, helping you to apply the law to the fact situations. My lectures are not merely for preparing you for the judicial service examinations. Each subject will be discussed in extenso so that it will help you even in the long run, whether you continue as advocates or whether you are elevated to the judicial service. Whatever be the position you later on occupy, these classes, these lectures will be of great advantage to you. Now we go to the, let's say I have given you a chart showing discharge and chart, framing of charge. First chart, chart A, is on discharge. Framing of charge arises only in a warrant trial, whether by a magistrate or by the sessions judge. Now, in a warrant trial, there has to be a charge framed to tell the accused that you are going to be tried for these such and such offences. He should know which offences are he has to face during trial. Now, in the case of a warrant trial by a magistrate, it is covered by Chapter 19 of CRPC, corresponding to Chapter 20 of BNSS. Now, there are two types of warrant trial, institution of a warrant trial. One is instituted on a police report. There the police will conduct investigation and finally submit a police report. The other is instituted otherwise than on a police report. Now, Part A of Chapter 19, that is Part A of Chapter 20 of BNSS, deals with cases, warrant trial instituted on a police report. And Part B of Chapter 20 BNSS deals with warrant trial instituted on a complaint, otherwise than on a police report, which is usually a private complaint. Now, Under section 239 CRPC, corresponding to section 262 of BNSS, the court shall discharge the accused if the court finds that the charge against the accused is groundless. See the chart, left hand side, left hand column. Then on the right hand side, you will find instituted otherwise than on a police report. Part B of chapter 20 BNSS. Section 245(1) says the magistrate shall take all evidence in support of the prosecution. Then, after taking all evidence, if the court finds that no case is made against the accused, if unrebutted, what do you mean by rebuttal? Rebuttal is when an evidence is adduced by a witness, then the opposite side will cross-examine the witness and try to rebut his evidence. When a document is produced, the opposite side will produce some other document to show that this document cannot be relied on. That is called rebuttal. So, if without any rebuttal, without any opposition by the other side, if the evidence as such makes out a case for conviction, then the court shall does not make out a case for conviction. The court shall discharge the accused in a warrant trial instituted otherwise than on a police report. Now, supposing, and under section, that is section 245(1) of CRPC corresponding to section 268(1) of BNSS. Now, under section 245(2) corresponding to section 268(2) of BNSS, even before the entire evidence is taken by the prosecution, is adduced by the prosecution, court has the power, the magistrate has got the power to discharge the accused if he finds that the charge against the accused is groundless. I have shown it in the chart. Then we come to the chart B regarding framing of charge. Regarding framing of charge, the parameters for the magistrate, whether instituted on a police report or otherwise than on a police report, that is private complaint, the parameters are common. If in the case of a police report, section 240 clause 1 corresponding to section 263 clause 1 of BNSS. Then under for warrant trial, otherwise instituted on a police report, instituted otherwise than on a police report, complaint case, section 2, that is part B, 246(1) of CRPC corresponding to section 269(1) of BNSS. The common factors for framing a charge as per these sections are: 1. If there is ground for presuming that the accused has committed an offense triable under chapter 19 CRPC, chapter 20 BNSS. Or 2, if the magistrate is competent to try the offense. And 3, if the offense could be adequately punished by the magistrate. All these three conditions should coexist for framing a charge against the accused. If these conditions coexist, the magistrate may frame a charge in a warrant trial, whether instituted on a police report or instituted otherwise than on a police report. Then we come to the still serious offences. Sessions case. Now take the first chart A. Discharge. Session trial. Chapter 18 CRPC, that is chapter 19 of BNSS. Section 227 CRPC corresponding to section 250 BNSS. So the section says the court shall discharge the accused if the judge considers that there is no sufficient ground for proceeding against the accused. If after considering the police report and the materials produced along with the police report, the court finds that there is no sufficient ground for proceeding against the accused, court shall discharge the accused. There is no point in calling upon the accused to face the ordeal of it, to face the trauma of a trial. A trial, as you know, it is a long drawn out process. The accused need not be driven to the trauma of a trial if the case does not make out there is no sufficient ground for proceeding against the accused. If the materials do not disclose sufficient ground for proceeding against the accused, then under section that is a provision under section 227. Now come to the chart B. When under section 228(1)(b), the court shall frame charge if there is ground for presuming that the offence, the accused has committed the offence, which is exclusively triable by a court of session. All offences are not triable by a court of session. There are certain offences which are shown by the first schedule to BNSS, where the last column of first schedule shows which all offences have to be tried by which all courts. In those against those offences which are shown triable as by the court of session, they are offences which are exclusively triable by a court of session. In such cases, if there is sufficient ground for presuming that the accused has committed the offence, then the sessions judge shall frame a charge. Only thing is, it should verify whether the offence is exclusively triable by a court of session. Why such a condition? Because court of session is an exalted court where graver offences are being tried. Therefore, if the offence is not exclusively triable by a court of session, but is triable exclusively by a magistrate, the precious time of the sessions court need not be wasted by proceeding to trial in a non-sessions offence. Therefore, court will have to consider whether the offence is a sessions offence, that is, triable exclusively by a court of session. Supposing the court finds that there is no case, the case is not, there is a case, but it is not exclusively triable by a court of session, but is triable by a magistrate, then instead of proceeding to trial, the sessions judge may frame a charge and then transfer the case to the chief judicial magistrate or to the appropriate magistrate and for trial. Because the offence is not exclusively triable by court, the precious time of the sessions judge need not be wasted by framing charge and then proceeding to trial by calling upon the prosecution to adduce evidence, etc. Therefore, the sessions judge has got the authority, the jurisdiction to say that no, this is not an offence which is exclusively triable by a court of session. Therefore, he will frame a charge and then transfer the case for trial to the chief judicial magistrate or to the appropriate magistrate who is competent to try the offence. These are the powers of discharge and framing of charge. Now, we will discuss a few general questions. Urvashi, will you read question number 1?
Yes, sir. Question number 1 is, what is a charge?
What is a charge? A charge in India corresponds to an indictment in English law and is very much more than a mere form. This was so held by a bench of the full bench of the Allahabad High Court in Devman Upadhyaya versus State, year 1960, Allahabad 1. So this case was taken up to the Supreme Court, and that was on a different point. The final verdict was on a different point. But on the question of charge, it was held that it is not a mere form. The full bench of the speaking through Justice M. Desai. The other judges were B. Mukherjee and A. Srivastava. Then again, charge is a precise formulation of the specific accusation made against a person who is entitled to know its nature at the very earliest stage. At the earliest stage itself, the accused is entitled to know what exactly is the specific accusation against him. It is right. It was so held in paragraph 17 of Varu versus Emperor, AR 1948, Sindh, page 40, AR 1948, Sindh, page 40. Again, by the Supreme Court in Yashar Singh versus State of Andhra Pradesh, AR 2004, Supreme Court 3030, AR 2004, Supreme Court 3030. Those of you who are interested in the corresponding citation, 2004, volume 11 SEC 585. 2004, volume 11 SEC 585. The judges are Durai Swami Raju and Justice Arijit Pasayat. Justice Arijit Pasayat being the author of the verdict. Then please read question number 2.
What is the necessity for a written charge?
See, why should there be a charge at all? The necessity of a system of written accusation specifying a definite criminal offense is of the essence of criminal procedure. It was so held by the Privy Council in N.A. Subramanya Iyer versus the King Emperor. N.A. Subramanya Iyer versus King Emperor. 28 Indian Appeals 257. 28 Indian Appeals 257. The judges are Chancellor, McNaughton, Davy, Robertson, and Linley. Now, again, we discussed the other day, Williams Lanny versus State of Madhya Pradesh, the locus classicus on charge, discharge, and framing of charge. AR 1956, Supreme Court, 1116, 116, I'm sorry. AR 1956, Supreme Court, 116. The corresponding citation is 1956 Criminal Law Journal 290. 1956 Criminal Law Journal 290. The great judges who constituted the constitutional bench are S.R. Das, acting Chief Justice, Vivian Bose, one of the authors of the judgment, Jagannatha Das, S.J. Imam, yet another author of the judgment, and N. Chandrasekhar Iyer, the third author of the judgment. All the three judges were rendered concurring judgments. We discussed the other day. Yes, now question 3. Please read.
Who is to frame charge, whether the police or the court, and what should be the language of the charge?
See, there is a misconception that it is for the police to frame charge. No, it is the court to frame charge. Police may file a charge sheet before the court, but after meticulously examining the materials produced along with the police report, the court has to frame the charge, and it should be carefully drawn up in accordance with the offence disclosed. The offence disclosed should be examined, and the charge should reflect the offence which has been disclosed by the materials. Krishnan Balakrishnan versus State of Kerala, AR 1958, Kerala 94. There's a beautiful judgment by a division bench of the Kerala High Court. The judgment rendered by Justice Raman Nair, who was Chief Justice for several years in Kerala. Justice P.T. Raman Nair. The other judge was Justice Shankaran. The citation is AR 1958, Kerala 94. Then the charge should be in the language of the court. This is what section 211 clause 6 of CRPC says. 211 of CRPC, that is 234 of BNSS. Clause 6 of 234 of BNSS says the charge should be in the language of the court. Why? And section 272 CRPC corresponding to section 307 of BNSS authorizes the state government concerned to determine the language of the courts in the states and other than the high courts. The section 272 CRPC corresponding to section 307 of BNSS authorizes the state government concerned to determine the language of the subordinate courts in the state, not the high court or the Supreme Court. Whatever be the language determined by the state government for the subordinate courts, that is the district judiciary, if the accused is not conversant with the language of the court, the charge should be read over and explained to the accused in the language known to him, and for that purpose the court can employ an interpreter if need be. See, supposing the court language as determined by the state government is English. Language of the court determined by the state government under section 307 BNSS is English. Supposing the accused does not know English, he knows only Hindi. There is no point in the court framing a charge in English and reading it in open court in English. He doesn't understand. Then what is the purpose of framing a charge? To tell him that he is going to be tried for such and such offences. And he should be asked whether you plead guilty or not guilty. How can he plead guilty or not guilty without understanding the charge? Therefore, whatever be the language of the court, the court has to frame the charge in the language of the court, but it has to be explained to the accused in the language known to the accused. Otherwise, it will be an empty formality without any purpose. No meaningful purpose will be served by reading out the charge in English. As per Article 348(1) of the Constitution of India, all proceedings in the Supreme Court and the High Court shall be in English language. Understandable, because from various High Courts, if judgments in various languages will come to the Supreme Court, they will find it difficult to decide the cases. Therefore, for Supreme Court, there is a ling language, a common language, that is English, that is fixed by Article 348(1) of the Constitution of India. But in the case of the district judiciary, it is for the state government concerned to decide the language of the court. And notwithstanding the language of the court, while framing charge in the language of the court will have to explain the charge to the accused in the language known to him. Please bear that in mind. Otherwise, he won't be effectively able to plead guilty or not guilty. Now, question number 4, please.
Supposing the accused does not know the language of the court, should the court explain the charge to the accused in a language known to him?
Yes, I already told you. Yes, this is because the purpose of framing a charge is to make the accused aware of the allegations against him and to give him an opportunity either to plead guilty or not guilty. If necessary, the court can employ the services of an interpreter. Supposing there is no interpreter available, even a lawyer who knows both languages, the services of a lawyer can be employed by the court. The court can request the lawyer to interpret the court charge in the language known to the accused. Question 5.
Is not the object of framing charge by the court just a statutory compliance or an empty formality or a ceremonial exercise?
Is it a mere statutory compliance or an empty formality or a ceremonial exercise? Certainly not. Its object is to warn the accused person of the case he has to answer. He is warned about the case which he has to answer. This was so held by the Supreme Court in B.N. Srikandaya versus State of Mysore, A.R. 1958, Supreme Court 672. A.R. 1958, Supreme Court 672. 3 judges. The judges are N.H. Bhagwati, J.L. Kapoor, the author, and Justice A.K. Sarkar. Again, Mohan Singh versus State of Bihar, 2011, Volume 9 SEC 272. 2011, Volume 9 SEC 272. This charge serves the purpose of notice or intimation to the accused, drawn up according to specific language of law, giving clear and unambiguous or precise notice of the nature of accusation that the accused is called upon to meet in the course of trial. See, you are going to be tried on this charge for such and such offences, and these are the punishments. Therefore, you are given notice. I give you notice that you will be tried before this court on this charge. Therefore, please tell me whether you did commit this offence or you did not commit this offence. So he will have to plead either guilty or not guilty. So that meaningful exercise will not be complete unless the court charge is framed in clear language and explained to the accused in the language known to him. You may refer to V.C. Shukla versus State, 1980 Supplementary SEC, 1980 Supplementary SEC 92, 1980 Supplementary SEC 92, corresponding to 1980 Criminal Law Journal 690, 1980 Criminal Law Journal 690. The great judge who authored the judgment is S. Murtaza Fazal Ali. S. Murtaza Fazal Ali. The other judges were P.N. Shingal and D.A. Desai. I'm sorry, there were 4 judges. P.N. Shingal, D.A. Desai and A.P. Sen. Murtaza Fazal Ali is the author of the verdict. Then the accused should not suffer any prejudice or failure of justice for want of requisite information of the offence and the details thereof. If the requisite information regarding the offence he has to face, or the offence he has to defend, or the case which he has to defend, and that may result in prejudice or failure of justice to the accused. Therefore, it is also important that if the charge is defective, that may result in failure of justice. and if the accused is really the culprit, he may get away, he may get scot-free merely because the charge was defective. So it has to be very important. It is very important. Rafiq Ahmad versus State of UP, 2011, volume 8 SEC, page 300. 2011, volume 8 SEC, 300. Judges are Dr. B.S. Chauhan and Swatandra Kumar. Justice Swatandra Kumar being the author of the judgment. Now, regarding the form of charge, in the form number 1 of the second schedule to BNSS, CRPC also, is the form prescribed for issuing summons to an accused person. See, after the first stage of a criminal case before a court, criminal court is, the court will first take judicial notice of the offence. Then the court will take cognizance of the offence, judicial notice of the offence. Then if it is a private complaint, the court will decide whether to proceed under section 200 of CRPC, that is chapter 15. It is chapter 14 in the BNSS. Court will decide whether to proceed under chapter 15 with section 200 as the first offence, as the first section. And once the court decides to proceed under chapter 15, starting with section 200 CRPC, the preponderance of judicial opinion is to the effect that court has taken cognizance of the offence. Court has taken cognizance of the offence. The taking cognizance of the offence is not something which is visible, which is something tangible. There is no definition also. What do you mean by taking cognizance of the offence? But it is the subject of, it has been the subject of judicial thought. Right from 1950 Supreme Court onwards, Supreme Court has been consistently taking the view that once in a private complaint, the magistrate applies his judicial mind for the purpose of proceeding under section 200 by recording the sworn statement of the complainant and the witness. Actual recording is not necessary. It is enough. If the magistrate decides to proceed under section 200, then he cannot turn back. He cannot retrace his step backwards. Once he has taken a decision to proceed under section 200, courts have taken the view that he can be said to have taken cognizance of the offence. Now, once cognizance of the offence is taken, next stage is whether there is sufficient ground for proceeding. Whether there is sufficient ground for proceeding. In a private complaint, cognizance might have been taken under by proceeding under chapter 12, chapter 15, by section 200 CRPC. But then that is not enough. It is not enough that the cognizance of the offence is taken. The magistrate has to further find that there is sufficient ground for proceeding. Supposing after taking cognizance, the magistrate is in a doubt whether he should proceed further, then he can enter upon an inquiry under section 202 CRPC. Section 202 CRPC, and he can conduct, even order an investigation by the police or some other person, not necessarily by the police, and he can also himself conduct an inquiry, and after inquiry, if he finds that there is sufficient ground for proceeding, then only he can issue process to the accused. So just because he has taken cognizance of the offence, he cannot issue process unless at the time of taking cognizance itself, he is convinced that there is sufficient ground for proceeding. There can be two situations: taking cognizance of the offence and arriving at the requisite satisfaction that there is sufficient ground for proceeding. In which case, immediately after taking cognizance, the magistrate can issue process. But there can be cases where after taking cognizance, magistrate is in a doubt whether he should proceed further, whether process should be issued, whether there is sufficient ground for proceeding. That is the real statutory ground for proceeding, whether there is sufficient ground for proceeding. Therefore, for arriving at that satisfaction, the magistrate can conduct a 202 inquiry. After inquiry, if he is of the view that yes, I have taken cognizance, now I am convinced that there is sufficient ground for proceeding also, then he can issue process to the accused. After issuing process, then only the question of accused appearing before the magistrate in response to the process will arise. Now, in a private complaint, form number 1 of BNSS, CRPC also, is the form prescribed for issuing summons to an accused person. It reads, your attendance is necessary to answer to a charge of such and such offences. Thus, right from the stage of summons process, the accused is informed that he has to answer a charge which is being leveled against him. That is the importance of framing a charge against him. So, even at the stage of process, he is told that this will be this will be the offense which may have to answer. And then, after appearing before the magistrate will hear both the prosecutor, public prosecutor, as well as the accused, and then peruse, scan all the prosecution record, and then decide whether to frame a charge against him or to discharge the accused. So it's a very responsible duty of the magistrate. It's a responsible duty of the defense of the public prosecutor also to appraise the materials produced by him for framing a charge. It is a responsible duty of the defense lawyer also to appraise the magistrate that these materials do not constitute the offense, do not constitute an offense at all. At any rate, they do not constitute sufficient ground for proceeding. Therefore, now under the BNSS, a right is given to the accused even before taking cognizance. Whether it is right or wrong, it's for the court finally to the apex court to say. But according to me, it makes a very serious departure, serious deviation from the CRPC, because the right of the accused to address the court, to participate in the proceedings before court, arises only after process. Now, at the pre-process stage, if at the stage of taking cognizance, which is universally taken before the appearance of the accused, if at that stage itself the accused is given an opportunity, he may try to prolong the case, he may try to protract the case, and the ultimate sufferer, the justice will be the ultimate sufferer. That is my view of the situation. Suppose, let us see what the apex court will say. Now, kindly read question number 6.
During the preliminary hearing under Section 227 of CRPC in a sessions trial, the sessions judge, while considering the record of the case, has to hear submissions of the accused and the prosecution also. During such hearing, is not the accused entitled to claim discharge by producing evidence either directly or indirectly through summons under Section 91 CRPC to show that the prosecution version is fake, false?
See, under 227, when a sessions judge considers the question whether to discharge the accused or to frame charge, there is an obligation of the court to hear the prosecution as well as the accused. Now, during the hearing of the accused, the defense lawyer says that I have got very important documents which, if produced, will show that the documents produced by the prosecution are false or not reliable. Therefore, I am entitled to a discharge. Therefore, please issue summons under Section 91 CRPC, that is corresponding to Section 94 BNSS, and please issue summons. This particular document may be called for and it may be used in evidence. That will show that the prosecution case will not be maintainable. The case of the prosecution will not lie. Please do that. This is the submission of the defense lawyer when he is argued, when his arguments are addressed, or when he is given an opportunity of hearing under Section 227 CRPC, that is corresponding to Section 250 of BNSS. Now, what is your view? Is he not entitled to argue that my documents also may be perused, and if they are considered, the prosecution, I can demonstrate before this court that the prosecution records or case is false. Therefore, the case should end here. Don't drag me to the trauma of a trial. That is his argument. At one stage, the Supreme Court accepted this argument, but then Later on, it was overruled by a 3-judge bench of the Supreme Court, holding that the section itself says that the record of the case, after considering the record of the case, what is the record of the case in a police charge case? In a case charge sheeted by the police, record of the case is the prosecution records produced by the police. That is the record of the case. No other record is there. There is no stage or provision enabling the accused to adduce evidence at that stage. Therefore, the only record in a prosecution at the stage of framing charge is the prosecution records produced by the investigating police officer before court, along with the charge sheet. Therefore, after considering the record of the case means prosecution records only. At that stage, defense is not entitled to produce any document, nor is the defense entitled to call upon the accused to issue summons under section 91 CRPC, 94 BNSS to call for any particular document which may be helpful to him. No, it's not possible. That was the earlier view was overruled by a 3-judge bench of the Supreme Court in State of Orissa versus Debendranath Padi. State of Orissa versus Debendranath Padi. The AAR 2005 Supreme Court 359. AAR 2005 Supreme Court 359 corresponding to 2005 Volume 1 SEC 568. 2005 Volume 1 SEC 568. The 3 judges were Y.K. Sabharwal, the author, D.M. Dharmadhikari, and Tarun Chatterjee. Bharat Parikh versus CBI 2008 10 SEC 109 is yet another decision taking the same view. Again, the judges here was Altamas Kabir and Dr. Mukundagam Sharma. Then Ajay Kumar Parmar versus State of Rajasthan. AR 2013 Supreme Court 633. AR 2013 Supreme Court 633 corresponding to 2012 SEC 406. 2012 SEC 406. The judges are Dr. B.S. Chauhan, the author, and F.M. Ibrahim Khalifullah. F.M. Ibrahim Khalifullah. The phrase hearing the submissions of the accused occurring in section 227 CRPC means hearing the accused on the record of the case. Hearing the accused on the record of the case, not any other extraneous matter, including any defense document. That was the same view was reiterated. Again, it was reiterated by yet another bench by speaking through Justice K.M. Joseph. Shivalinga Murthy, ME. Shivalinga Murthy, ME versus CBI, Bangalore. Shivalinga Murthy, ME versus CBI, Bangalore. AIR 2020 Supreme Court 331. AIR 2020 Supreme Court 331 corresponding to 2020 Volume 2 SEC 768. Sanjay Krishan Kaul and Justice K.M. Joseph authoring the judgment. Again, it was even earlier it was held that the defense of the accused is not to be looked into at the stage of framing charge when the accused seeks a discharge. This was the view already earlier taken also. 1995, that is State of Jammu and Kashmir versus Sudarshan Chakar. State of Jammu and Kashmir versus Sudarshan Chakar. Sorry. AR 1995 Supreme Court 1954. AR 1995 Supreme Court 1954 corresponding to 1995 4 SEC 181. Dr. A.S. Anand and M.K. Mukherjee. And this has been followed by Justice K.M. Joseph in Shivalinga Murthy, ME versus CBI Bangalore. AR 2020 Supreme Court 331. There is one decision by a 2-judge bench of the Supreme Court in Nitya Brahmananda alias K. Lenin versus Gopal Sheelam Reddy, Aka Nitya Bhaktananda. AIR 2017 Supreme Court 5846 corresponding to 2018 2 ACC 93. AIR 2017 Supreme Court 5846 corresponding to 2018 2 ACC 93 by Justice A.K. Goyal and Uday U. Lalit. They have held that even though the accused cannot ordinarily invoke Section 91 CRPC, that is Section 94 of BNSS, that does not debar the court from exercising the power under Section 91 CRPC in the interest of justice. Now, I would respectfully submit that the interpretation given to Section 227, that is 250 of BNSS, by a three-judge bench, which held that record of the case means only the prosecution record. If the accused cannot invoke Section 91 CRPC, that is Section 94 of BNSS, and summon a document which will not constitute the record of the case, how can the court create a record of the case by exercising its power under Section 91 CRPC, that is Section 94 BNSS? Because the power under Section 91 CRPC corresponding to 94 of BNSS is a suo motu power, not a power available to a party. When you file a petition under Section 91 invoking the power of the court to summon a particular document, you are only invoking the power of the court. The power of the suo motu power of the court is being invoked for summoning a document. When the accused cannot invoke that power, how can the court invoke that power? I am at a loss to understand. Anyway, let us see the final fate of that decision. There is yet another decision. It was held that the embargo against the accused producing evidence at the stage of framing charge before the trial court will not be applicable to the High Court in a proceeding under Section 482 CRPC. That is, 482 CRPC is corresponding to Section 528 of BNSS. Taken from that is proceeding taken before the High Court from the order of the trial court. And the High Court, it was held that the High Court is free to consider the material which may be produced on behalf of the accused before the High Court to arrive at a decision whether the charge framed against the accused is benchable or not, provided the material produced is of a sterling quality, unimpeachable document. If it is an unimpeachable document, the High Court can, in a proceeding under Section 482, look into the document. There is some justification in this view because even though trial court cannot, is a proceeding under Section 482. What is the wording of Section 482 corresponding to Section 528 of BNSS? I will read that. 482. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court. Nothing in this code means even Section 227 CRPC. Even the earlier sections in this code will not, shall not be deemed to limit or affect the inherent power of the court. Therefore, notwithstanding any provision to otherwise in the code, the High Court is at liberty to exercise its inherent power, and provided the accused has produced a material of a sterling quality, which will clearly falsify a prosecution record, then certainly the High Court can look into that document. This was the view taken in Rukmini Narvekar versus Vijaya Satardekar, AR 2009 Supreme Court 1013, AR 2009 Supreme Court 1013, corresponding to 2008 14 SEC page 1. Altamas Kabir and Markandeya Kadju are the judges. Altamas Kabir and Markandeya Kadju are the judges. Now we pass on to question number 7. Kindly read, Urvashi.
Yes, sir. Why is it that for discharging an accused, Section 227 CRPC in a sessions trial, Section 239 CRPC in a warrant trial on a police report, and Section 245 CRPC in a warrant trial otherwise than on a police report use different phraseology?
These sections, though the principle is same, the sections use different phraseology. In a session trial, the case cannot be straightaway instituted before the session court. You cannot file a private complaint before the session court. There are exceptions, but ordinarily, before a session court, you cannot file a private complaint alleging of commission of offences under the Indian Penal Code and under the Indian Penal Code. The session court, because the session court can take cognizance of an offence as a court of original jurisdiction only if the case has been committed to it under section 193 CRPC. Now, session court cannot straightaway entertain a private complaint. It is for the magistrate concerned to entertain a private complaint alleging offences under the Indian Penal Code, and after the necessary inquiry, the magistrate will have to finally commit the case to the court of session, and it is only on a committal that the sessions court can take cognizance of the offence. That is why you will find different phraseology in section 227. The institution of the case, either by way of a police report or by way of a private complaint, can be made only before the magistrate concerned, who will have to commit the case to the court of session. And when the sessions court receives the case upon a committal by the magistrate concerned, that court has to conduct a preliminary hearing regardless of the mode of institution of the case. That is why the specific wording of section 227. But that is not the position in a warrant trial. Separate procedure is laid down under Part A of Chapter 19 CRPC, that is Chapter 20 BNS, and for warrant trial in a case instituted on a police report. Likewise, Part B of the said chapter lays down the procedure for warrant trial instituted otherwise than on a police report. In a warrant trial of a case instituted on a police report, the magistrate considers only the police report and the documents sent along with it under section 239 CRPC, corresponding to section 262 BNSS. But in a warrant trial of a case instituted otherwise than on a police report, the magistrate has to take all the prosecution evidence after the appearance of the accused. That is the reason why different phraseology has been employed in the three sections I'm sorry, referred to in this section, in the question. Please, we will pass on to question number 8.
What are the criteria laid down by the courts for discharging the accused or for framing a charge against the accused?
Now,
Shall I read
before you read that, we noticed while discussing that chart A and B that the main criterion for discharge is when the court finds that the charge is groundless, or when there is no sufficient ground for proceeding. These are the two criteria laid down in the appropriate sections of the CRPC corresponding to BNSS also. The charge is groundless, or when there is whether there is sufficient ground for proceeding, etc. Now, contrary to these two parameters, these two criteria, the apex court, Supreme Court of India, in various decisions, have laid down different yardsticks. I would say that it has contributed to the confusion. It becomes confusion confounded. But there is one advantage for that. If in a particular case the court wants to discharge the accused, the court can make use of those decisions, those criteria laid down by the Supreme Court, enabling discharge. Supposing the court wants to frame charge against the accused, the court can rely on those decisions which enable framing of charge. For that purpose, this confusion, these different criteria laid down by the Supreme Court will be relevant. Now you read the various criteria. I have categorized the decisions on the basis of the criteria laid down by the Supreme Court. Please read one.
Point number 1. Charge can be framed if there is prima facie case made out to proceed against the accused.
See, prima facie case, you don't find it in the section. Prima facie, if there is prima facie case against the accused, the charge can be framed. Okay, the decisions, I have given the decisions. It is not necessary for you to read all those decisions. You are screen sharing the citation. The viewers can see the citation. Then second criterion. See, please read too.
Yes. Charge can be framed only if there is grave or strong suspicion that the accused had committed the offense.
These expressions you won't find in this section. Charge can be framed only if there is grave or strong suspicion that the accused has committed the offense. You don't find it in the section, but this is what the judges held in the following decisions. The decisions are given.
Point number 3.
Yes.
If there is strong suspicion which leads the court to think that there is ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused.
Again, the same reiteration of the same thing. If there is strong suspicion, then the court cannot say that there is no sufficient ground for proceeding. Same reiteration of the earlier principle only. Then 4.
Court will be justified in discharging the accused if the evidence produced gives rise to some suspicion. In other words, mere suspicion is not enough for framing charge.
So some suspicion, if there is some suspicion, court can discharge the accused, not frame the charge. If there is strong suspicion, court can frame the charge. These are all judge-made criteria, not given in this section. Yes, for that also I have given the catalogued the verdicts. Then 5.
The court cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broad probabilities of the case, the total effect of the evidence and the documents produced before the court, any other basic infirmities, etc. However, at this stage, there cannot be a roving inquiry into the pros and cons of the matter and the weight of evidence as if the court were conducting a trial.
See, court shall not conduct a roving inquiry. All the documents, in fact, that is precisely what the section says. After considering the records of the case, that's what the section says. Then the court should not conduct a roving inquiry. The court shall not consider the weight of evidence on record as if the court were conducting a trial. These are the criteria laid down in those decisions. Yes. Then, 6th criterion.
Holding of a mini trial at that stage is to be avoided.
So, holding of a trial is certainly not is to be avoided, because you are only after framing charge and taking the plea of the accused, and if he pleads not guilty, then only the trial will start. So, but holding of a mini trial at that stage, something like a mini trial only, by considering the documents, hearing the arguments of the prosecution and the accused with regard to those documents, virtually a mini trial. Anyway, that has to be avoided. Yes, trial, of course, one can understand, but don't conduct a mini trial also. That is one criteria. Yes. 7th criteria.
6. Even if the court thinks that the accused might have committed the offense, charge can be framed.
See, court has deviated from the earlier criteria. Strong suspicion must be there. That is diluted. If the accused might have committed the offense, charge can be framed. Yes. Okay.
Criteria number 8.
Yes.
Possibility as against certainty is sufficient for framing charge.
So it is possible that the accused had committed this offense. Charge can be framed. What happened to the strong suspicion? Gone. Yes. Then 9th.
9. At the time of framing charge, the materials produced by the prosecution have to be accepted as true. The probative value of those materials cannot be gone into by the court.
This is a correct criterion, because prosecution record means what the prosecution, what the police, investigating police officer has produced along with the charge sheet. Those documents alone have to be considered. The accused cannot produce other documents to say that these documents are not acceptable. Therefore, the documents as such, documents on their face value have to be accepted as true. That is a correct criteria. Yes. Then 10.
10th, it is immaterial whether the case is based on direct or circumstantial evidence.
Exactly. That is a requirement of the evidence. Evidence need not be direct in every case. There won't be any direct evidence in some cases. There will be only circumstantial evidence. Both are enough. Direct or circumstantial evidence alone is sufficient for framing charge or discharging the accused. For both. Yes.
Analysis of all the materials by deciding the pros and cons, reliability or acceptability of those materials not to be undertaken.
The analysis of the materials by deciding pros and cons, reliability or acceptability, those materials not to be undertaken. Supposing a document on the face of it is not acceptable, on the face of it is not reliable, can it not be accepted? Of course, the accused cannot uh, say that I have produced some document or I have in my custody certain documents. If those documents are produced, these documents will become unreliable, unacceptable. That is not permissible. But on the face of it, if a document is not reliable, acceptable, nothing wrong in the court considering that. Anyway, that is also a criterion laid down. 12th criterion.
12th criteria. Order should not be one virtually passing an order of acquittal in the garb of discharge.
This is a good criterion because you cannot pass a virtually an order of acquittal or a order of discharge under the garb of a discharge, acquittal or conviction. See, acquittal or conviction should ultimately take place after the entire evidence is adduced, and that accused is also given an opportunity to adduce rebuttal evidence, if any, etc. So after the whole gamut of the trial is over, then only there can be a conviction or an acquittal. But at the stage of discharge, you cannot issue an order of conviction or discharge, acquittal under the garb of a discharge. Under the pretext of a discharge, court cannot pass a virtually an order of acquittal or an order of conviction. Corrected criterion. Yes. 13.
Criteria 13. At the stage of framing charge, the court is concerned only with the question as to whether prima facie there appears the existence of any material and not the sufficiency of the materials.
What is relevant is the existence of the material. So, supposing prosecution has produced certain documents in support of its allegations, if the court need only consider whether in support of those allegations any material has been produced. The question whether those materials are sufficient to establish the prosecution allegation need not be looked into. But there can be situations where sufficiency of the material also can be looked into. Why not? Supposing the document produced prima facie do not establish the offense alleged, court can certainly look into sufficient. Here, I can make an allegation and produce some irrelevant material. So, I cannot be told that, supposing I am the prosecutor, I can make an allegation and produce some irrelevant material. And if the argument is there is material, don't look into the sufficiency of the material. Only the existence of the material need only be looked into means I have produced material, so don't look into the sufficiency. That is not permissible. On the face of the document, materials produced, if they are ex facie not acceptable, certainly the court can look into the materials. But only thing is, they cannot be looked into for the purpose for evaluating some other material which is not before court. Yes. Question 40.
Criteria number 14th. While considering a discharge application, the court is to exercise its judicial mind to determine whether a case for trial has been made out or not.
Sufficient ground for proceeding is the criterion, not for case for trial or conviction. Of course, case for trial has to be made out, definitely, undoubtedly. But that is there is sufficient ground for proceeding. There is sufficient ground for proceeding is the statutory criterion. The court need only look into that. For that, court can also say that this is a case for trial. So I am framing charge. Let the accused face the trial. Correct. Criterion 15.
Yes. If the evidence which the public prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross examination or in rebuttal evidence, cannot show that the accused committed the offense, then there will not be sufficient ground for proceeding.
Yes, this was the criteria laid down by the Supreme Court in P. Vijayan versus State of Kerala, year 2010 Supreme Court 663. That was a case where a Naxalite by name Varghese was allegedly murdered in a police encounter, in an alleged police encounter. In fact, that police officer, P. Vijayan was a police officer. He wanted a discharge. Then the case, very same case came up before me while I was in the High Court of Kerala. I did not accept the plea of discharge. I said this is not a case where discharge can be easily given. The case he has to face the trial. The Supreme Court finally held that he has to face the trial. The discharge was not accepted. I am happy that my decision was affirmed. There, we among the district judges or the district judiciary, there was a great judge who was subsequently elevated to the High Court. He used to tell the judicial officers that if your decision is affirmed by the High Court, you should be happy because you were able to do justice in advance. Then, supposing your decision was overruled or reversed by the High Court, you should be happier because your illegality was not perpetuated. That was the great mindset of a district judge in Kerala who was subsequently elevated to the High Court, and he finally retired as the Chief Justice of Kerala High Court. Yes. With that, we have completed the criteria. Question number 8. Tomorrow, we will start from question number 9. Shall we conclude today?
Yes, sir, indeed. I think
Thank
we
you.
have completed 1 hour. That would be enough for our viewers also, sir. So I really want to thank you, sir. Thank you so much for this enlightening session. I enjoyed it myself, and I'm sure so did our viewers. And from the chats, we can see that a lot of your fans are here. So thank you so much, sir, for sparing your time and being
Thank
with
you.
us. Definitely, we look forward to other parts also.
You
So
did your role
thank you very much.
exceptionally well. You did
Thank you,
your
sir.
role
It's my pleasure,
exceptionally
sir.
well, Urvashi. Thank you.
Thank you so much. Thank you. Before we end, for our viewers, I just want to say that in case you are preparing for judiciary and you are aspiring judges, then please check out Livelaw Academy, which is offering a value packed opportunity, and they are coming up with a judicial service examination preparation course. And this course is designed basically to help you prepare for your exams. The classes will be, conducted by expert faculty, including retired judges. And one demo you have already seen and you already know now. And you will be learning from actual case studies and also very easy to follow study material. And there is an affordable fee. So please do check this out. And you can enroll. The Academy is also offering a 20% scholarship at the moment. So you can please visit www.livelawacademy.com. Once again, thank you so much, sir. We'll
Thank
see you
you.
again.
Thank you. Thank you.